Hello, my name is Jeff Bolender. I'm an attorney in Southern California. Thank you for attending this legal education course. Our topic is insurance law, specifically the rules relating to liability insurance. This CLE is designed primarily to teach the fundamentals of insurance policy analysis. Now, analyzing an insurance policy is a form of contract analysis. And as with any type of contract analysis, the main purpose is usually going to be to determine whether either one of the contracting parties has committed a breach, and if so, what the remedies are going to be. In order to do that, it's always going to be necessary to review the contract language and sort out the rights and obligations of the parties. Today's focus is the contractual duty of a liability insurance company to furnish a lawyer when the policyholder has been served with a lawsuit. Now, when I refer to policyholder, I'm referring to the named insured or anyone else who might qualify under a liability policy and who has been served by a third-party plaintiff. Now, what we're talking about today is the duty to defend. From the policyholder's perspective, it's the right to be lawyered up. A denial of coverage can have devastating consequences to the policyholder, but fortunately for policyholders, many disclaimers can be successfully challenged. This is largely because California law tilts decidedly in favor of policyholders on the duty to defend. So today I'm going to go through and discuss the process of reviewing a liability policy and evaluating the merits of a denial of coverage. And the ultimate objective, of course, is to determine whether or not grounds exist to mount the challenge to the insurance company. The workshop format consists of a skills component in lesson 1 and a substantive law component in lesson 2. In lesson 3, I want to discuss policy exclusions and how to evaluate disclaimers of coverage for the purpose of potentially challenging a denial of coverage. In lesson 4, I want to switch from the duty to defend to the contractual right of an insurance company to defend, and that includes the insurance company's right to select the defense counsel that it wants to defend the policyholder. Finally, in lesson 5, I will address the very important issue of remedies. And there I'm hoping to convey the unique nature of a breach of the duty to defend and the unique challenges that a breach presents in making the policyholder whole when the insurance company has wrongfully declined to defend the policyholder in a lawsuit. All right, this is lesson 1. This is the skills component. When an insurance claim is denied, take 2. All right, this is lesson 1. This is our skills component. When an insurance claim, take 3. All right, this is lesson 1. This is our skills component. When an insurance claim is denied, the insurance company is ordinarily going to be required to write a disclaimer letter explaining the basis for its coverage decision. Now, I've drafted many disclaimer letters For nearly 20 years, I represented insurance carriers as both an insurance policy analyst and an insurance litigator. I now represent policyholders exclusively, and when we are consulted, our first step is to outline the facts and the policy language in the disclaimer letter that purports to support the denial of coverage. Using those grounds as a starting point, we then perform a policy analysis and evaluate whether our conclusions differ from those in the disclaimer letter. All right, it's now time to roll up our sleeves and take a look at an insurance policy. Now, everybody knows that insurance policies are not fun to read. They're dense, they're filled with fine print, they're confusing. Oftentimes they can be quite thick. How does one take a stack of policy documents and drill down to the core components? Well, really three things. First, it's important to understand how to organize the policy documents for a review to determine what the policy consists of, what's important, what's not. Second, it's important to learn or to understand how to isolate the critical policy language that forms the basis of the dispute. This involves understanding how to find the language and spot the issues. The third step is that it's necessary to analyze the disputed language and evaluate the disclaimer letter and its rationale based upon the correct legal standard. The first step is C for contract. Declaration pages are the natural first step in a coverage review. Many of the policy forms will refer back to information in the declarations. So a review of the policy is not complete unless the forms are reviewed in conjunction with the information in the declarations. Now, there are usually multiple declarations, so you'll want to search through those, look for supplemental declarations, and identify important information such as policy limits and important schedules such as location and projects. Effective dates are particularly important in any coverage analysis. The policy benefits of most insurance policies are going to be triggered by specified events taking place within the effective dates of coverage. So you want to write these in your notes when you're analyzing the policy and keeping those dates uppermost in your mind as you proceed through your analysis. Modern insurance products are complicated and consist of many forms, especially insurance products that provide property coverage and commercial liability coverage. Don't be intimidated by all of the forms because virtually all of these can be quickly ruled out. What you want to do is find what's usually called a schedule of forms or a schedule of endorsements or an index of forms, and then study it carefully and look for coverage related forms and any amendments to those forms. Now, today we are going to look at a commercial general liability coverage form. This is a very common form of liability coverage in the United States. Many businesses in this country have similar or identical insurance protection. And we're talking about businesses of very small to very large businesses of many different types of operations. This CGL form is a 2013 version of a form that's been around since the mid-1980s. A vast body of case law exists that has interpreted the various provisions in all of the 50 states. And it's really a great place to begin learning how to analyze liability insurance, or any type of insurance for that matter. Once you find the coverage form, head straight to the insuring agreement. Now we're looking at one of several insuring agreements that you'll find in a commercial general liability policy, CGL policy for short. The insuring agreement is where you will find the grant of coverage. That's the promise of the insurance company to extend insurance protection if a covered liability event takes place. Now, let me briefly comment about the basic structure of how underwriters grant coverage. Underwriters will draft a broad insuring agreement that embraces a entire class of insurable risk. The coverage is then narrowed and tailored to specific underlying underwriting intent through multiple exclusionary clauses. And these exclusions appear in a later section of the policy. As we go forward with our coverage analysis, it's important to remember the distinction between an insuring agreement and an exclusion, because that has implications in connection with the rules of interpretation and the burdens of proof. Now, let's focus on the first sentence of the insuring agreement. A CGL policy, a commercial general liability policy, like all liability insurance, affords two primary insurance benefits. The first benefit is called the indemnity benefit, and that is represented by the first sentence on the screen. This means that if the insured, if the policyholder is held liable, the insurer will pay the claimant, the third-party claimant, the third-party plaintiff, the amount of the judgment. That promise is limited under this CGL policy to compensatory damages because of property damage or bodily injury. Now, that's the indemnity benefit. Let's look at the second sentence, which is the promise to defend. This is called the defense benefit. That promise is limited to lawsuits seeking damages that are potentially within the scope of the indemnity benefit. So you can see in the first and second sentences, we have two related duties, both of which are equally important, as we'll discuss, but each of which is separate and distinct, and each of which has a different purpose, a different scope, and a different trigger. The highlighted sentence is today's focus, the duty to defend. The promise of the insurance company to furnish and fund a lawyer to represent the policyholder in the defense of lawsuits seeking damages for defined losses. That was the first step, C for contract. Let's move to the second step, A for analysis. How do you know which part of the coverage form to read and analyze? The disclaimer letter is certainly the starting point and usually the end point. Those letters usually cite or quote the disputed policy language, but it's still important to be able to spot the issues. And so I'm going to briefly go through the four major issue groups and the natural sequence of a coverage analysis of a liability claim. The first issue group deals with policy provisions describing who qualifies as an insured. Now, I've been using the generic term policyholder today, but the term insured person generally means any individual or any company who qualifies as an insured. Only those who qualify as an insured are entitled to policy benefits, including the right to a legal defense. Now, if the person seeking a defense qualifies as an insured, the coverage analysis naturally proceeds to the second major issue group, the insuring agreement. We just looked at one and we saw that it has several elements: damages, defined losses. There are two other elements. I don't have time to go through those in my remarks today. However, we'll go forward. If the lawsuit does seek damages falling within the insuring agreement, the analysis then turns to exclusionary clauses. We'll discuss these in just a few minutes, but basically for now, exclusions essentially take away coverage that was granted by the insuring agreement. So if the claim does not fall within the insuring agreement, then there is no reason to move to exclusions. If no exclusions apply, then the insurance company must immediately agree to defend, because that means there is a potentially covered claim or claims in the lawsuit, and therefore the insurance company owes a duty to defend because of the potential for coverage. Now, the final issue group is a material breach of policy conditions. What this really means, or what this refers to, are policy provisions that impose upon the policyholder a duty to either act in a certain way or refrain from acting as a condition of coverage. Breach of condition in the third-party liability insurance context will rarely excuse the duty to defend. Let's move to the third step of our three-step analysis. We had C for contract, A for analysis. Now we're going to go to R for rules of interpretation, or rules of the road. Insurance companies are permitted under California law to choose the language they put into their policies, but they are not permitted to arbitrarily choose their preferred interpretation when a claim arises. In other words, an insurance company can't make a promise and then arbitrarily decide how it chooses to interpret that promise once an insured event takes place. Insurance companies must interpret the policy in a fashion that is consistent with the prevailing legal standard. So let's talk about that for a moment. If a court is called upon to resolve a controversy regarding the interpretation of an insurance policy, the court is going to primarily limit its interpretation to the four corners of the policy and apply the plain meaning of the language in the policy. In other words, the court is not going to consider anything other than the plain meaning of the language in the policy to make its initial interpretation. Now, language will not be enforced by courts, however, if it is not plain, conspicuously placed in the policy, and clear. If policy language is ambiguous, courts will usually find in favor of the policyholder under the rationale that the insurance company is the drafter of the contract of insurance. But a court is not going to find an ambiguity unless the key language is subject to multiple reasonable interpretations, and one of those constructions provides coverage, and one of those constructions does not. To round out my comments on the rules of interpretation, the rules of the road, let me leave you with this, that the case law for decades has clearly reflected in general, a pro-coverage tilt. Insurance agreements are interpreted broadly, restrictive and exclusionary language is interpreted narrowly, and when it comes down to the duty to defend, the case law generally is going to reveal that all doubts are decided in favor of the insured. If you mention the words liability insurance, most people will not think about the duty to defend. Most people tend to think about liability insurance in terms of the type of policy they have and the amount of limits available. A policy's limit is a feature of the indemnity benefit, but the insurance protection afforded by the defense benefit is unquestionably of equal importance, and in many instances, it's even more important. Since at least the 1960s, the California Supreme Court has recognized that liability insurance carriers owe a very broad duty to defend. And beginning in the early 1990s, the California Supreme Court issued a series of opinions that confirmed its expansive view of the duty to defend and drew a very sharp distinction between the duty to indemnify and the duty to defend. The court characterized the contractual obligation to defend as a service that is owed by the insurance company to avoid or at least minimize the policyholder's liability, and that the defense obligation may arise as soon as damages are sought. Now, in my judgment, the Supreme Court was sending a clear message to lower courts and insurance companies that entitlement to a defense is vitally important to policyholders, and that duty to defend attaches completely and immediately when a potentially covered claim is tendered for coverage. Let's talk about when the duty to defend starts and stops. Under a general liability policy, the duty to defend arises as soon as the insurance company receives notice of a lawsuit seeking potentially covered damages. Now, unlike some other types of policies, a CGL policy only applies to lawsuits, not a pre-lawsuit claim. But the mere fact that a lawsuit has been filed and served will not alone trigger the defense. It's important to give the insurance company notice as early as possible and to follow up. Now, attorney fees that are incurred by the policyholder prior to tender may not be covered under a strict reading of the insurance policy, but some insurance companies are negotiable with respect to pre-tender fees, but they are usually going to have a contractual basis to deny any fees incurred prior to tender. Now, it's important to remember that insurers must base their decision to defend on the information available at or around the time of tender. They must consider both the express and implied allegations. They must also consider any evidence that's extrinsic to the pleadings against the policyholder, if available, and consider whether that extrinsic evidence raises a potential for coverage, even if the pleadings alone do not. Additionally, insurance companies must consider the potential that the complaint could be amended to add a covered cause of action. Now, insurers cannot lawfully deny a defense and justify their failure to do so by later discovered evidence. So it's important to remember that the evaluation of the duty to defend is based upon the information available to the insurance company at or around the date of tender. Now, once the duty to defend attaches, once the obligation to defend has been activated, it endures until the end of the case or until the insurance company can conclusively demonstrate that all potential for coverage is removed from the case and there are no remaining cause of action or damages that could be covered. A very high threshold. I want to turn from the temporal scope of the duty to defend to the substantive scope. Let's look at hypothetical number 1. Rachel is facing liability on 5 counts and only 2 are potentially covered: slander and libel. Now, defamatory torts are covered under a different insurance agreement in the CGL policy that we looked at earlier. So we have 5 counts against Rachel, only 2 are potentially covered. This is what is known as a mixed action. Now, Rachel's insurer contends that under the policy, it is only required to defend the slander and libel claims. Those are the 2 claims that are potentially covered. Rachel contends that a full defense is owed under the policy's terms. So who's right? Well, in the bus case, the Supreme Court agreed with the insurer under similar circumstances that the contractual duty only extended to potentially covered claims. It reasoned, however, that insurers cannot meaningfully defend less than an entire lawsuit. The court essentially concluded that in a mixed action, the duty to defend extends beyond its contractual scope by operation of law. So in this case, Rachel is going to be protected during the pendency of the lawsuit because the insurance company is going to owe a prophylactic duty to defend the entire lawsuit. Now, in a situation like this, the insurance company is going to agree to defend Rachel while reserving its rights to deny coverage for the 3 claims that are not covered. Now, under the bus case, the insurance company also has the right to, subsequent after the lawsuit is over, to seek reimbursement from Rachel for any attorney fees and litigation expenses that were incurred solely to defend the 3 non-covered claims. The Supreme Court reasoned here that insured or policyholders such as Rachel are essentially unjustly enriched, and therefore the insurance company is going to have a right under a quasi-contract theory to seek reimbursement. That completes lesson 2. In lesson 1, we sharpened our contract analysis skills. In lesson 2, we learned about the policyholder's right to be lawyered up. Let's now turn to lesson 3 and look at exclusions and how to evaluate and challenge a denial of coverage. When an insurance company receives a claim for insurance benefits, it's going to open a claims file, assign a claim number, and a claim adjuster. And one of that adjuster's first steps is going to be to perform a basic coverage review. The adjuster will first determine if the party seeking coverage, that we call that the tendering party, if that party qualifies as an insured, and if so, whether the claim is within the meaning of the insuring agreement. If the answer is yes, then take two. When an insurance company receives a claim for insurance benefits, take three. When an insurance company receives a claim for insurance benefits, it's going to open up a claims file, assign a claim number, and a claim adjuster. And one of the first steps that the adjuster is going to take is to perform a basic coverage review. The adjuster will first determine if the party who is tendering the claim and seeking coverage, whether that party qualifies as an insured, and if so, whether the claim against that party is within the policy's insuring agreement. And we went over this before. If the answer is yes and yes, the adjuster then turns to exclusions. We discussed earlier how exclusions essentially take away coverage for claims that are within the insuring agreement. Now, there's also something called exceptions, and an exception is a clause that describes a situation where the exclusion does not apply. All right, so insurance companies and insurance company adjusters cite exclusions in their disclaimer letters at least 50 to 60% of the time as the basis for denying coverage. Under California law, the insurance company the exclusion must conclusively eliminate the potential for coverage under any theory of liability. So the burden of proof is very high. There is a very high threshold for the insurance company when it cites an exclusion as a basis to avoid a duty to defend. Now, in my experience, insurance companies quite often cite exclusions prematurely. Okay? Now, why is that? Many exclusions will apply, if at all, only to the duty to indemnify, and only after liability and damages have been proven at the end of the case. At the outset of the case, the insurance company and its adjuster are not permitted to adopt unwarranted factual assumptions about what might happen in order to invoke an exclusion. In hypothetical number 2, this is a scenario that I've seen in many different times. Take 2. In hypothetical number 2, we have a scenario that I've seen many times. Here, an incident took place at Sam's bar, and Diane sues the bouncer and sues Sam. Each denies all allegations. They also generally deny the allegations. Take 3. In hypothetical number 3, we have a scenario that I've seen many times. Here, an incident took place at Sam's bar, and Diane sues the bouncer and Sam. Each defendant denies all allegations. Sam's insurer refuses to defend either defendant, citing an intentional act exclusion. So let's look at this exclusion. This is a statutory exclusion for intentional acts. It is found at section 533 of the California Insurance Code. And so whenever you get an exclusion, you want to begin by studying the words very carefully, and you want to find the focus, the analytical focus of this exclusion. So if you look at this exclusion, you can see pretty quickly that the analytical focus is the willful act of the insured. So intent to harm is the analytical focus of this exclusion. That is what the insurance company would have to prove in order to invoke the exclusion. That's the first thing you see. Second, you'll see from the language here that a separate analysis is required for SAM and a separate analysis is required for the bouncer. The words willful act of the insured has been interpreted to mean essentially that each tendering party is required their own separate claim and their own separate analysis. Third, we see in the second sentence that the exclusion does not apply to losses caused by negligence of the insured or its employees. Fourth, we also see here that the language does not clearly eliminate the duty to defend. The language of the exclusion refers to a loss caused by the willful act of the insured. It doesn't really speak specifically to the insurance company's ability to defend allegations of a loss caused by the willful act of the insured. So bearing these in mind, let's briefly look at the insurance company's denial of coverage here. Let's look at SAM first. SAM's direct tort liability under these facts may be limited to negligent hiring or negligent supervision, not actual intent to harm anyone. The facts are very vague here, I admit that, but it's certainly possible here that the incident that occurred was just between Diane and the bouncer. So there's no basis whatsoever under these facts to deny coverage for Sam because his liability may be solely for negligence other than vicarious liability. Now the bouncer, like Sam, denies all allegations. And by doing so, the bouncer has placed at issue all of the allegations. All allegations are disputed. And in fact, under this facts, neither Sam or the bouncer are even admitting that an incident took place at all. The only basis the insurer possesses under these facts for a denial is Diana's allegations and her pleadings. And that's just not going to be enough to conclusively show that there's no potential for indemnification and therefore no duty to defend. So under these facts, Sam's insurance company will need to reserve its rights, and that will allow it to provide a defense while preserving its right to later deny coverage if the exclusion applies to the duty to indemnify. Now in the next chapter, we'll look at the impact of an insurance company's reserving its rights upon the insurance company's ability to select its own defense counsel and control litigation decisions. And before we move on to lesson 4, let me provide some closing thoughts about analyzing exclusions. There are many different types of exclusions. We just went through one. There are many different types of different subject matters and so forth. So I'm going to leave you with a generalized approach on how to deal with exclusions because you may encounter all different types. Number one, it's important to study the text of the exclusion to find its core criteria, such as intent. What is it that the insurance company has to prove to invoke that exclusion? Secondly, consider in your mind, based upon that analysis, the type of evidence that would be needed to invoke that exclusion. What would the insurance company need to refer to conclusively show that the exclusion applies at the outset of a case? Now, remember, when you're doing this analysis, to distinguish between the different triggers. The duty to defend is determined at the outset of the case. It's based upon the mere potential for coverage, and it is very, very, very broad. Adopting this type of approach to analyzing exclusions may lead you to the conclusion that the adjuster, in denying the claim, has made assumptions, unwarranted assumptions, in order to avoid a defense. All right, that's lessons 1 through 3. We addressed the contractual duty to defend and the corresponding right of the policyholder to a complete and immediate defense. Let's now take a look at the right to defend and conflicts of interest. When insurance companies agree to defend a policyholder, they customarily select and retain an outside law firm to defend the policyholder. This creates a three-way arrangement known as the tripartite relationship. The insurer pays the defense counsel to defend the policyholder. The lawyer's primary duties are owed to the Take two. When insurance companies agree to defend, they customarily select and retain an outside law firm to defend the policyholder. These firms are sometimes referred to as insurance defense firms. This creates a three-way arrangement known as the tripartite relationship. The insurer pays the defense counsel to defend the insured defendant. Sometimes these attorneys are referred to as being on the insurance company's panel counsel, defense counsel. Now, the defense counsel's primary duties are owed to the policyholder, the insured defendant, that is. But under California law, both the insurer and the policyholder are considered to be the clients of the attorney. Now, the tripart relationship functions efficiently in the vast majority of lawsuits, unquestionably, and that has been around for at least 50, 60 years now. But joint representation occasionally gives rise to a conflict of interest on the part of the insurance company's preferred counsel. So let's talk a little bit about the history of this unique and interesting area of law before we move on to the current status of the law in California. In the 1960s and 70s, a few courts began observing that joint representation may occasionally function to prejudice the policyholder. In the executive aviation case, a wrongful death action was filed after a mysterious plane crash, and in the ensuing litigation, an issue arose as to the appropriate standard of care. That issue hinged upon an unresolved factual issue, and that was whether this mysterious crash took place during a common carriage flight, or was it a sales demonstration flight? In other words, it was unclear whether the flight at issue was a demonstration flight to possibly sell the plane, or was it a transportation flight? And based upon that, there would be a different standard of care. Now, due to limitations in the pilot's license, a coverage would only attach if the flight was a sales demonstration flight. Now, the facts of this case are peculiar and largely only of historical significance, but the bottom line here is that the policyholder was being represented by both defense counsel and the insurance company's coverage counsel. Ultimately, this all came to the attention of the Court of Appeal, and the court expressed concern about the risk to a policyholder of joint representation, especially where there is no evidence that the policyholder was made aware of the implications early on of joint representation. Now, executive aviation is one of the first cases to recognize that occasionally an insurance company must surrender its contractual right to control the defense and allow the policyholder and its attorney to make the decisions, and that the insurance company has to pay the freight here. Now, fast forward about 10 years or so, and the conflict of interest issue arose again in the famous Cumis case. Now, like the earlier executive aviation court, the Cumis court seemed concerned about the institutional relationships between these outside insurance defense firms and the insurance company adjusters. Now, the facts of the Cumis opinion, the specific facts have largely been eclipsed by the basic rule that was derived from the holding and from the basic factual paradigm that this case represents. Let's talk about that for a minute. In the classic Cumis paradigm, coverage hinges upon a disputed issue in the litigation, namely whether the policyholder's liability producing conduct was negligent or intentional, covered or non-covered. That basic paradigm, intent versus neglect, is the prime main example of what is known as a steerable issue. A steerable issue is one that can be steered away from coverage by the manner in which the defense counsel litigates the case. Now, the holding in Cumis was arguably overly broad, and in the years immediately after the Cumis opinion, policyholders were demanding Cumis counsel in every single case in which the insurance company reserved its rights. And this was about 10 years before I became an attorney, but I understand anecdotally that it was a bit of a mess. And so the legislature and various interest groups got together a few years later and enacted Section 2860 of the California Civil Code. Now, 2860 seeks to broadly govern the relationship between an insurance company and its policyholder when a claim for independent counsel is made, and in those instances when the insurance company agrees to recognize the insured's right to independent counsel. Now, Section 2860 clarified and limited the basic rule in Cumis concerning when a disqualifying conflict arises. It also gave insurance companies some very important rights. It gave insurance companies the right to limit hourly rates to a particular statutory standard. It afforded it requires arbitration of certain types of fee disputes. It provides various other types of rights to the insurance company and the policyholder as it relates to cooperation, information sharing, and so forth. By and large, Section 2860 has worked rather well, and there is a significant body of case law interpreting its provisions. Now let's go over a hypothetical here. In hypothetical 3, Lucy has filed a complaint against Desi alleging a variety of business torts. And Desi's insurance company agrees to defend and reserves rights on all issues. And by all issues, that it would include any kind of intentional act exclusions and other types of coverage issues that would be traditionally a steerable issue. And not all issues are steerable issues, but you can assume for the purposes of this hypothetical that the reservation of rights letter does contain steerable issues. So the insurance company denies Desi's demand for independent counsel. Who's right? Well, on these facts alone, I think the insurance company is going to win the argument that there is no current disqualifying conflict of interest on the part of the attorney that the insurance company selects to defend the case. Now, why is that? Well, when the California legislature enacted 2860, it wanted to limit the breadth of the Cumis opinion. And I think this is partly speculation, partly research, but I believe that the legislature was concerned that a bright line rule would turn every reservation of rights letter into an insurance dispute, which would ultimately have the effect of increasing premiums. And so the court inserted permissive language in the standard for determining when a conflict arises. So in the dynamic concepts case that came out, within a few years of the Cumis opinion, the court there made it clear that the party demanding independent counsel has to do more than point to the reservation of rights letter and a theoretical conflict. The dynamic concepts court found that the conflict has to be significant and actual, not merely theoretical. And so the court in dynamic concepts and other courts have said that the insurance company and the policyholder and all other concerned need to work with each other and try to work as a common team towards a common goal to protect the insureds. So what this really means is that demands for independent counsel, that there's no bright line rule, and it comes down to a case by case analysis. Now let's look at one other hypothetical here. In hypothetical number 4, Archie was in a car accident while driving Edith's car. Both he and Edith are sued. This is your garden variety personal injury auto accident case. Now, Edith's insurance company agrees to defend both of them, but it reserves rights because the policy has an exclusion for drivers who are living with Edith at the time of the accident. Okay, so both Edith and Archie demand independent counsel and the insurance company says no. Who's right? Okay, the insurance company is going to win here almost certainly. And the reason for that is that the coverage issue is extrinsic to the issues in the personal injury litigation. The fact that Archie may or may not have been living with Edith at the time of the accident is not an issue in the litigation. It's a fact, it's an objective fact, and it may or may not be knowable, but it is extrinsic to the pleading, and therefore it does not fit the classic Cumis paradigm of being of having an overlap between a liability issue and a coverage issue. So Edith's insurance company is not going to owe a duty to provide independent counsel because there is no disqualifying conflict of interest on the part of the attorney selected by the insurance company to defend Edith and Archie. All right. Now, I'm going to leave this section with a couple of slides that discuss, that essentially sets forth an analytical checklist for evaluating whether or not a reservation of rights creates a disqualifying conflict of interest. I don't have time to go through all of these. I will let you just read that on your own time. But these bullet points will assist you in determining whether or not in the particular issue that you're looking at, whether the insurance company has reserved rights on an issue that is analogous to that paradigm Cumis factual scenario. And that really is going to usually be whether there is an overlap between between a factual issue in the litigation and a coverage issue that the insurance company has reserved rights on. All right, we have now reached lesson 5, and I want to talk about remedies very briefly. This webinar is really not focused on remedies. It's really focused on the duty to defend, but remedies is perhaps the most important part of the duty to defend. And the reason for that is because a breach of the duty to defend can have such devastating consequences on the policyholder. In many instances where the insurer refuses to defend, the policyholder is not going to be in a position to fund its own defense. And even if the policyholder can afford to pay a lawyer, it's probably not going to be able to fund a robust, effective defense in many situations. So how do you make a policyholder whole when the insurer refuses to defend? How do you measure the detriment that flows from the failure to have an insurance company in your corner? Well, I think that the answer is that there is no answer, because you don't know how things would progress. You don't know how things would be different. You don't know how the lawsuit would have taken a different path had you had an insurance company in your corner with an experienced, competent attorney advising you what to do and when to do it. So what am I getting at? What I'm trying to explain is that the breach of the duty to defend often involves more than merely adding up your damages with a calculator. The insurance company has said that the policyholder is entitled to the insurer's superior financial resources. And when the insurance company does not agree to defend and make those resources available, the policyholder is going to be in a position to later argue that it sustained more than the damages that could have been invested in the defense. That concludes my remarks. Thank you for attending this legal education seminar. Thank you.